13 CF 641. Add the requirement for batter's intervention program, no violent contact with Ms. Pearson, and then all the other original requirements and some fees and costs. The state agrees to dismiss 20.
It may be best to have them run together and have this 23 CF 127 also put on for February 21st at 9 a.m. just in case there's a way to resolve both cases. There is my understanding is there's a 3-year suspended sentence in 20 CF 563, but there is no BOP report as of this afternoon.
Okay, the court will enter a not guilty plea on the new charge, on this new charge, 23 CF 127. We'll come back and track it with the other charge, the BOP, and we'll come back on February 21st, 9 a.m.
Thank you, Your Honor.
Thank you. Next is Kelsey Falk.
Kelsey Falk.
Travis case on behalf of this we have a plea agreement to be filed in her case. I can get her to sign the plea agreement, Your Honor. Okay. Went over it with her in the back. Your Honor, may I approach? You may.
I've got a score sheet, no objection, I score.
Very good, thank you. Would you announce the terms of the plea agreement, sir?
Yes, Your Honor. Let me lower the podium here a little bit.
Thank you.
Ms. Falk will be entering a plea no contest as charged on 23 CF 20. Should be adjudicated guilty, sentenced to 6 months in the county jail, as concurrent with credit for all time served. $615 in court costs, $150 the defendant fee. She'd ask for 24 months to pay those fees before they're sent to collections. No probation followed.
So is the 6 months for each of the charges?
Yes, Your Honor. I had to write that in at the bottom. I did not write concurrent, so I wrote the sentences will be concurrent to each other.
Okay, very good. And would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
It's a state in agreement.
This is a state's agreement, Your Honor.
Very good. And so, Ms. Falk, you did hear the terms of the plea agreement with that your attorney stated, and I see that those same terms are in the plea agreement that you signed at the end. Have you gone over this in detail with your attorney?
Yes, sir.
Had all your legal questions answered about it?
Yes.
You understand that by entering this plea agreement, waiving the right to go to a trial and contest all this, this will be a final adjudication of your case.
Yes, sir.
You believe it's in your best interest to enter into this plea?
Yes.
And you're doing it freely and voluntarily?
Yes.
Okay, do you have any further questions about the plea?
No.
Okay. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on both charges. You'll be sentenced to 6 months in the county jail on both charges. They will be served concurrently at the same time. You will get credit for all time served. In addition, there's some fees and costs that you have 24 months to pay. and there'll be no probation after you get out of jail. Okay, any questions?
No.
Thank you very much.
Thank you.
Nicole Howe.
Your Honor, Travis Gates on behalf of Ms. Nicole Howe. We have a plea agreement to be filed in Ms. Howe's case.
22 CF 2496.
29. Your Honor, I was showing Ms. Howe a copy of the score sheet. May I approach, Your Honor?
You may. Thank you.
No objection to the score sheet that was filed. Ms. Howe will be entering a plea of no contest as charged. It's going to be adjudication of guilt, sentence to time served, $615 court costs, $150 defender fee. She has for 24 months from date of release to pay those fees before they're sent to collection. The state will take no action on the FTA associated with this case.
Stating agreement.
That is the state's agreement, Your Honor.
Thank you very much. Ms. Howell, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You hear your attorney state the terms of the plea agreement? You put your hand down. Did you hear your attorney explain the terms of the plea agreement?
Yes.
And I see those same terms are contained in the written plea agreement that you signed at the back. Have you gone over this agreement with your attorney, made sure you had all your legal questions answered?
Yes.
Let me ask it another way. Do you have any other legal questions or any other questions that you need to have answered regarding this?
No, sir.
So you're clear, this is what you want to do here today?
Yes.
And you understand you're waiving the right to go to a trial. This will be a final adjudication of your case. Do you understand that?
Yes.
I'm sensing some sense of reluctance. If you got a question, talk to your attorney. Is there something I'm not getting a sense that she's clearly resolved.
Yes, Your Honor, and I've had Ms. Howell before. She comes across as a bit timid, and I think that may be a lot of what it is, Your Honor. She and I discussed this plea agreement. It is a time served. She has been previously adjudicated. There is no probation follow, so she would be eligible for release today, as long as the court states no action on the FTA. Otherwise, we'll get an email from the jail.
Absolutely. And the court will based upon that explanation, the court will accept your plea agreement here today. There's a previous adjudication of guilt. You'll get credit for time served. There's some fees and costs. The state will not take any action on the failure to appear associated with this, okay?
Okay.
Okay. And you'll have no probation after this. You have 24 months after you get out to pay the fees and costs. After that, it goes to collections. Any questions?
No.
Okay. Good luck.
Hannah Jenkins.
Your Honor, this is Ms. Jaggers before the court in 22 CF 3144. I'd asked the state about a little less jail. They were going to let me know.
We had discussed, the state can do 3 months with all terms as previously discussed. So that would be 3 months. That would be 3 months to close up the misdemeanors. Probation will be as charged in this one. Yep.
Yes, Your Honor, and my conversation with Ms. Jaggers is she'll take that. If we can pass her, I will write the plea, go over with her, and we can handle that today.
Very good.
Yeah.
Hang out back. TJ, keep her here.
Okay.
James Angel James.
Yeah, this is Ms. James before the court. We have a plea agreement to be filed in her case. It'll be to a misdemeanor, so there'll be no score sheet. May I approach, Your Honor?
You may. Thank you.
Your Honor, Ms. James will be entering a plea of no contest to a lesser included offense of possession of paraphernalia. Pertinent statute number on that, because I've got it somewhere.
That is it.
I have my cheat sheet. There it is. I'll leave it up here just in case. But that is correct. It's
Let the clerk keep the order straight.
Yes, Your Honor. I just know sometimes the clerk asks, and we have a cheat sheet to be safe.
So I'm glad she didn't ask me. So. Go ahead.
There'll be adjudication of guilt. Ms. Jenkins will be sentenced to 90 days in the county jail with credit for all time served. There'll be no probation to follow. Assess the standard court cost of $207, $150 public defender fee. Ms. James would ask for 24 months to pay those outstanding fees before they're sent to collection.
Very good. Ms. James, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state, you can put your hand up. You heard your attorney state the terms of the plea agreement.
Yes, sir.
And is that your understanding? I see that the same terms are contained in the written plea agreement.
Yes, sir.
And you've signed the back of that. Have you gone over this with your attorney? Make sure you had all your legal questions answered? Yes?
Yes.
We're recording this. And you do understand that this is the final resolution of your case? And
Yes,
you're
sir.
waiving the right to go to a trial, et cetera?
Yes, yes, sir.
You believe it's in your best interest to enter into this?
Yes, sir.
Based upon that, the court will accept your plea. Be an adjudication of guilt on the lesser included possession of paraphernalia. The court will sentence you to 90 days in the county jail. You will get credit for all time served. There'll be no probation to follow. The court fees and public defender fees, you'll have 24 months to pay before they're sent to collection. Okay. Question?
No, sir.
Thank you.
Next week, Hector Acosta Gonzalez, Acosta with an A.
Okay. Stage, you ready to announce on this with no interruptions? You just go to the lectern. Would the state announce the case?
Yes, Your Honor. This is 23 CF 66.
Okay, so Mr. Acosta, you're here on these new charges. You do have a right to have an attorney appointed. You wish to have an attorney appointed, or are you going to hire private counsel?
I need a attorney.
Okay, so the court will appoint the public defender. You got to file the application section.
I asked on the jail, and they never gave me the paper.
Yeah. Okay, we'll give it to you. Anyway, so what we're going to do is I'm going to enter a not guilty plea for you today. So that preserve all your rights. We'll come back on pre-trial on 4/12, 9 a.m. And hopefully you'll be able to meet with your attorney before then and figure out kind of where you're going. Okay?
Thank you.
Thank you.
Do you have we're not finding a charge document, that information.
Mr. Acosta?
Yeah, Acosta Gonzalez.
One was filed on January the 30th. I have
John, what is the
right here. I'll print it right now.
Okay. Just scan that over here.
Your Honor, I'm giving you my card, but I'll have to do a conflict check.
Thank you. Okay. David Archer.
David Archer. Select.
The state announce again.
Yes, Your Honor. I'm sorry.
23 CF 100.
Your Honor, I know that an information has not been filed in this case, but that's because I just got the certified copy of his DHS&B record. He does have another case, which is, I believe, on the very next plea day. Is it possible for us to put these two cases together?
What is the on?
Should be the 21st.
That's not.
Just need we want to track the cases together. Okay.
Who's this?
Archer.
This is on a different case, Mr. Medina. When is it scheduled
On the
for?
21st. Scheduled for your plea day, Your Honor.
This is one of my clients?
Yes. This is a different case. You're not assigned to this case yet because they haven't filed an information.
Okay.
So we're gonna just continue this arraignment until February 21st in the morning, which will track with the other one that you've already been appointed to, and so you can,
Yeah, I'm not familiar with this situation, but I'll do
That's
a
fine.
conflict check, Your Honor, and come see him if he's my client. Thank you.
okay.
Antoine Barrett. What's your first name, Mr. Archer?
David Joseph Archer.
You've already sent somebody up and asked you to talk to me.
Okay. Mr. Medina, I think this is your case with Mr. Archer, Mr. Barrett.
Yes, Your Honor, I need a moment with Mr. Barrett to see if he wants to do the deal, Your Honor.
Sure, go ahead.
This is, you don't need to do it. Your Honor, Mr. Antoine D. Barrett is before the court, 23 CF 42. He's asking for information this court, I don't think, can give him. Basically, he's been offered on a felony battery charge, simple battery, year probation. I've indicated to him that as far as I know, that would subject him to a violation of probation if he has probation in Holmes County. He represented to me he did. I don't represent him in Holmes County on anything. And he was wanting assurances from the court that this would not violate him. I don't think the court can give him that assurance. I would think that
That's why you got an attorney, counsel. That's why you have an attorney.
Right. I wasn't looking for insurance to see that it won't. I was just seeing what possibilities.
I can't give legal advice. Even if I wanted to, I can't give legal advice.
Subject me to a violation? That's all I'm trying to figure out.
it can happen. We don't know if it will. It certainly can, and you should assume that it will. If you don't want to do it, then we'll plead not guilty.
Okay, very good. The court will enter a not guilty
Well, Your
plea.
Honor, he's indicating he does want to do
Yeah, I
it.
told you.
Yeah, I've been over it with him, so if you have any questions? Okay, Your Honor, we'll enter a not guilty plea. He said I couldn't answer his
I just
questions,
said I'd take the deal.
I can't, maybe he could relieve the public defender, because I'm not sure what he
Well,
wants.
I would like to take the deal.
Why don't we just ask him and let me inquire of him? If he's comfortable and you're comfortable, we'll figure out where we're going. You good with that?
Right. I was just trying to figure out one thing. Apparently he didn't answer that question, so I'll just take the deal.
Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes.
Okay. What's the terms of the agreement?
If he signs it, it's adjudication of guilt on simple battery, which is a first-degree misdemeanors, section 784.03, subsection 1B, 11 months, 29 days probation, no violent contact with the victim, who's in the courtroom, I believe. Status intervention program, substance abuse evaluation and treatment. The evaluation would have to be completed within 30 days of release. Commence any recommended treatment within 60 days of release. Maintain gainful employment or file 2 applications per week. Court costs, PD fees.
Is that the state's agreement?
Yes, Your Honor, and I did speak with Ms. Smith, who's the victim, and I went over this offer with her. She indicated that she understood.
And she's okay with it? Okay.
Your Honor, seems to be one of the pages is missing, so I just want to make sure that he has a right to read all the pages, and I don't know where it went, but I'm going to make sure that I give him one with page 2.
Yeah, all these papers are the same.
So he probably needs to go back and read page 2, because he probably hasn't read it.
We'll deal with this. Let's go ahead and pass over this so you can read everything. We're very sensitive to make sure that you understand what you're doing and you're not being.
That's all I was trying to figure out. I'm not just trying to be pushed along.
That's what we don't want to do. We don't want to be pushing you along. We want to make sure you got a chance to review everything. Double, okay? Seriously. Okay. Blankenship. Thomas.
Blankenship?
The state.
Yes, Your Honor, this is 23 CF 68. Mr. Blankenship is charged with domestic violence, battery by strangulation, and resisting an officer without violence.
Okay, Mr. Blankenship, you do have a right to have an attorney appointed with these new charges. Do you wish to have an attorney appointed?
Yes, sir.
Court will appoint the public defender, but this is only provisionally because you got to fill out the affidavit, your financial affidavit, etc. But the court will enter a not guilty plea on your behalf, so you have a chance to meet with your attorney, okay?
Yes, sir.
And we'll come back on April 12th for pretrial. In the meantime, you can meet with your attorney and kind of figure out where things are going with it, okay?
All right, thank you, Judge.
Thank you.
What's your first name?
Thomas Blankenship. Thank you.
Here's my card.
Chase Gary.
Come see you after we do a conflict check. All right.
I got Robert Brewster. Robert Brewster.
Got Brewster. Okay, let's look at Brewster. Okay, got it. Brewster.
Your Honor, this is 23 CF 60. Mr. Brewster is charged with grand theft and engaging in a business without a license.
Okay. Mr. Brewster, you do have a right to have an attorney appointed. Do you wish to have an attorney appointed here today, or you want to hire private counsel?
I wish to have an attorney appointed.
Okay, the court will appoint you the public defender. This is only provisionally, so you got to fill out the affidavit, make sure you qualify. I'm going to appoint today, and I'm going to enter a not guilty plea, so it will preserve your rights. You won't give up any rights. We'll come back on April 12th on pre-trial. In the meantime, you'll have a chance to meet with your attorney and kind of figure out what's going on, and there can be a resolution of the case.
Your Honor, before you order that, I've been locked up 4 years and 3 months. I tried a dozen times to resolve this while I was incarcerated, and I sent $100 to the plaintiff. I sent $100 to state attorney. They sent it
Mr.
back.
Brewster, this conversation needs to be with your attorney, and I suggest that
We can't get anything resolved today, is what
I don't know anything about the case other than just reading what the charges are, so.
Your Honor, Shaggers is seen this morning, so we're going to go to Randall Gecker next. Gecker, sir. Here's a card. I'll
Come see if there's not a conflict, and we'll see what we can do as soon as possible.
This is Mr. Randall before the court. We have a plea agreement to be filed. I just need Mr. Gecker to sign it. He and I discussed it prior to him coming out.
Okay.
I will let the court know that he and I had talked about it. There was some hesitation on Mr. Gecker's part to 14.3. Unfortunately, his parents are in a situation where they need him out, which is more important than potentially fighting the case or resolving the case. So he's agreed to the misdemeanor offer the state's made today.
Very good. You're going to announce.
Yes, Your Honor. There'll be no score sheet necessary. It's going to be a plea of misdemeanor. Approach that, Your Honor.
Yes, sir. Thank you.
Your Honor, Mr. Gecker will be entering a plea to count 3 of the information. The state's agreed to dismiss counts 1 and 2 in exchange for the plea. to be adjudicated guilty, sentenced to 11 months, 29 days of probation. It's going to be through state probation, so we're going to ask the court to waive the supervision fees. $463 in court costs, $150 public defender fee, first offense DUI school, victim impact panel, 10-day vehicle impound, which can be waived by a parole and probation if he provides proof he doesn't own a vehicle, $500 fine, 50 hours of community service work, required to do a substance abuse evaluation and then recommended treatment, random analysis, maintain gainful employment, or complete 3 job applications per week. And then I wrote in on the court's copy 6-month driver's license revocation as well.
You good with that state's agreement?
That is the state's agreement, Your Honor.
Mr. Geek, how do you pronounce your last name? Gecker or Gecker? Gecker. Mr. Gecker, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
You heard your attorney state the term, you can put your hand up. You heard your attorney state the terms of your plea agreement. I see those same terms are contained in the written plea agreement that you've signed. You've gone over this written agreement closely with your attorney, make sure you have all your legal questions answered.
Yes, sir.
You understand you're waiving the right to go to a trial, giving up some valuable legal rights, force the state to prove their case beyond a reasonable doubt.
Sir, yes, sir. Yes, sir.
And I know you have some misgivings about it, but I just want to make sure you're doing this freely and voluntarily. For whatever reasons, it's up to you, but you're doing it freely and voluntarily. Nobody's coercing you to get you to enter into this plea. Correct?
Yes.
Okay.
I just want to
you had all your legal questions answered about this? Okay. Very good. Based upon my testimony, the court will accept your plea agreement. There'll be an adjudication of guilt on the on count 3, 11 months, 29 days probation, fees and costs, and then the other issues, substance abuse evaluation, recommended treatment. The only thing I would suggest to you, you've only got a year on probation. Jump on all these requirements. I want you to be successful. You don't need to be dealing with this thing. Get it done.
All right.
Okay?
Yes, sir.
Jump on it early so you're not, 11th hour threatening the violation and incarceration. All this.
All right.
Okay?
Yes, sir.
Okay. Any questions?
No.
Thank you very much.
In your honor, Mr. Gecker can have till 8 o'clock tomorrow to report to probation.
Yes.
8 o'clock tomorrow, won't be there.
Well, I'm going to catch the bus.
Your honor, he's going to be catching the bus in the morning with the court behind to do, say, noon to give him time.
When does the bus
I
run?
think we'll leave between 7 and 8. I'm going to try to be on it in the morning because I won't have a ride this afternoon.
Okay. So it'll be, you can probably be able to get there by 9?
Yes, sir.
Okay, that's fine. 9. Okay, Hawkins?
Yes, sir.
State. This is case number 22 CF 3154, petty larceny, third or subsequent conviction.
Yes, Your Honor. This is 1 count of felony petty theft. The state's offer is plea as charged, adjudicate credit for time served, restitution in the amount of $3.29, public defender fee if applicable, and court costs of $5.
I'm afraid to ask. Sir, did you hear what the state said?
Yes, ma'am. Is that credit for time served?
Credit for time served.
Okay, thank you, man. Okay. Good service.
So you won't be on any probation.
Okay.
There will be an adjudication of guilt.
Yes, sir. Thank you.
$3.29 restitution.
Yes, sir. Chief, have a drug.
You do that?
Yes, sir. Yes, sir.
Okay. And you understand that by entering into this plea agreement here today, this will be a final resolution of your case. You don't have to come back to court.
Okay, sir.
And
yes, sir. I appreciate it.
You'll get credit for time served, so you're not doing any probation. So this will pretty once you get all the paperwork and stuff, you'll be done with this.
Okay.
Except for the restitution and the payments.
Okay, I'm trying to get my Social Security.
So all the monies will go to collections state? You only give
can
them
have 180.
180 days. You can pay them in 6 months.
Okay, 6 months, so yes,
Okay.
sir. All right, yes, sir.
And, very good. Record, accept the plea, adjudication of guilt, credit for time served,
Okay,
restitution 6 months to pay the court costs.
okay, yes, sir.
Okay.
Thank you, sir.
Oh, hold on.
Restitution,
Okay,
$3.29.
$3.29. That was not a mistake that you heard that.
And there's also going to be a $3.50 fee if he pays through the clerk. Are you having him go to the victim and pay them?
What is, is he paying $3.29 to?
The state would waive that condition, Your Honor.
Okay, we're waiving, you don't have to pay the $3.29, but you got to pay the other fees that are unfortunately a lot more than that, okay?
yes, sir, yes, sir.
Okay.
I think the fees, because there's no agreement written up, is it?
Outline the fees. Is it?
It should be $5.15.
Okay.
It's,
180 days, I think I heard.
yes.
All right, I was going to need prints, here we go.
Thank you. You gotta go get some prints.
And Your Honor, for the record, his score sheet, he only scores 37.4 points, so this would not be a downward departure.
Thank you.
And I do have a copy if the court will allow me to refer.
Yes, ma'am.
How you doing, Mr. Jackson?
Thank you.
That means I did that. Your mama called me. What did she say?
Okay. What is this case?
Your Honor, this is Guy Keith Jackson, case number 22CF3182.
Gotcha.
Yes, Your Honor, I was informing Mr. Jackson that his mom had called me last week and I was filling him in on the conversation.
Okay.
Mr. Jackson's going to be entering a plea, no contest as charged, Your Honor. There's going to be a score sheet for the states.
Sorry, who's this?
Guy Jackson.
Yes.
I'll approach with the plea agreement and I'll set it down.
Your Honor, may I approach the score sheet after I hand it over to the case?
Yes, Your Honor, this is directed. Yes.
39. Be careful. Violation. I'm paying this thing off. Within this month.
May I approach the
Do we have a copy of the score sheet?
Court will give me a second. I'm going to give Mr. Jackson the copy of my score sheet so that he has it for his records. There you go. All right, Your Honor. Mr. Jackson's going to be entering a plea no contest as charged. It's a withhold of adjudication, and all counts will be placed on 2 years of probation concurrent. We're going to waive the supervision fee, $5.15 court costs, $150 defender fee, no contact with Ms. Christina Avery, 24 hours community service work, and then reserve of restitution of Ms. Christina Avery.
Okay. Is that the state's agreement?
It is the state's agreement, Your Honor.
Mr. Jackson, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, Mr. Jackson, you heard your attorney state the terms of your plea agreement. I see those same terms are contained in your written agreement, which you have also signed. Have you gone over these in detail with your attorney, make sure you had all your legal questions answered?
Yes, sir.
You understand you're waiving the right to go to a trial to contest this. This will be a final adjudication of this case. You understand that?
Yes, sir.
You believe it's in your best interest to enter into this?
This is Travis Gates. Of course it's in my best interest.
It's because he recommended it.
No, not just because he recommended it, because he's a powerhouse.
Okay. I'm glad to hear that. And we need some strength and balance. Okay. I'm stunned. You've made me speechless.
Hey, what can I say? Listen, proof is in the pudding.
There was a reason I was laughing as I approached Your Honor.
Okay. So you had all your, do you don't have any other questions? You good? You're voluntarily entering into this? Huh?
Yes, sir.
Very good. Based upon that eloquent answers to your questions, the court will accept the plea, withhold of adjudication on all counts. 24 months probation on each of the counts. They'll all be served concurrently. Waive the cost of supervision. You got the fees and costs. Pay attention to the no contact with Ms. Avery. Don't know what the situation is there. Your obligation to stay away from her. It's not vice versa. She walks up to you, you're in violation, you can get thrown back in. So stay away from her, okay?
Oh, trust me, I got security. She's not coming near me.
Okay, good. So, and they'll reserve as to restitution, and if that comes up, your attorney, meet with your attorney, figure out where you're going with it, okay?
All right.
Thank you. Have a good day. Okay. Jaggers?
Jackson? Or is it
Shaggers, Your Honor, we passed so I could get the agreement. As soon as I get done with Mr. Jenkins. As soon as we get done with Mr. Jenkins, I'll walk back and get that taken care of with Mr. Shaggers. Your Honor. Good for you, you don't score, but if you want to, you don't score, understand? You go to prison for that. Yeah, this is Mr. Jenkins before the court. I had a plea agreement signed. Unfortunately, after speaking to the state, we had to amend the charges he was pleading to maintain the withhold in this case. It'll be a plea of lesser included offense in count 1, the dealing of stolen property by trafficking, which is a second-degree felony, and then as charged in count 2 of the information. Looking at the score sheet, we have no objection as scored, Your Honor.
You may. You announce it.
Yes, Your Honor. It'll be withhold of adjudication on the lesser included offense of count 1 and as charged, and count 2 placed on 24 months of probation concurrent. We're going to waive the supervision fees at standard court costs of $515, $150 public defender fee, no trespass in any Walmart, reserve over any restitution to Walmart. For probation clarification, Mr. Jenkins has a hold from Alachua County and a potential hold from Marion County. It's my expectation he will not be released, so he will not be reporting. We'll need to get up to see him before he gets transported to another county. And then we've got no objection in transferring to Michigan where he's a legal resident. And just so probation's aware, he's also on probation in Santa Rosa County and Walton County too.
You got all that?
Yes,
Okay. Mr. Jenkins, would you raise your right hand? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God.
This is the truth, Your Honor.
Okay. You heard your attorney state the terms of your plea agreement, which I see is also contained in your written plea agreement,
Yes,
which
Your
you've
Honor.
signed. You've gone over this in detail with your attorney, make sure you understand all the legal issues involved with this.
Yes, Your Honor.
Importantly, you're waiving the right to go to a trial, contest these things, confront witnesses, etc.
Yes,
I believe it's in
Your
your best interest to have this finally adjudicated here today,
Yes,
finally
Your Honor.
resolved.
Yes, Your Honor.
You're entering into this freely and voluntarily.
Yes, Your Honor.
No recourse to get you to enter.
No.
Okay. Based upon that testimony, the court will accept your plea agreement. There'll be withhold of adjudication. On all counts, you'll receive 24 months probation. They'll all be served at the same time, concurrent. okay? Waive the cost of supervision, cost and fees, no trespass of any Walmart, reserve restitution at Walmart. And you've got these holds. And the court has no objection to transferring probation, although there's a procedure that you have to go through, and not guaranteeing anything, but the court's not objecting to it, okay? Any questions? Thank you.
Thank you, Your Honor. It's one that I think probation will have to do that before that he gets released.
Sure. Okay, we're gonna, what do we got?
This is you wanted to go over his plea agreement, Antoine.
Okay.
Yeah, I mean, I'll do my best. No, it makes sense. Yeah.
Give me the name again, I'm sorry.
Brewster. Antoine Barrett.
Barrett.
B-A-R.
Your Honor, Mr. Barrett and I had a chance to talk. He didn't have any questions on the page that was missing before, and I think that he's already indicated on the record that he wants to go ahead and sign the agreement, which I have been over with him, so that's where you sign if that's what you want to do. I think what happens is the page has just got out of order. Let's see.
She was put back in as, needs to go completely.
Good morning. We're going to take a break here in a second. We'll get him on.
Please sign on this one. I don't know why that's got multiple pages. That one.
Same thing.
It's the same thing.
Okay, Mr. Barrett, I swore you in earlier, so I think I did, didn't I? Swore you in already? You're still under oath. So you had a chance to go through and read all the plea and sentencing agreement, get all your questions answered regarding?
Yes, sir.
I just want to do two things when we ask you all these questions. I repeat them all over and over all day long. Two reasons. One, I want to make sure you understand what you're doing, and you're doing it freely and voluntarily. Nobody, as you said when you walk, you don't want to be kind of railroaded down. We don't want to do that either because it's important. Now, this is an important junction point because you're resolving this case at this point, at this level. You've got some other stuff to do, but this is important.
Your Honor, I can announce the terms. Again, it may be a good idea.
Go ahead.
Your Honor, there were some abbreviations here, and I stated previously adjudication of guilt on simple battery, first degree misdemeanor. The statute is referenced in the agreement. 11 months, 29 days probation, which is listed as 11.29 months probation. No violent contact with the victim. And just for the record, the victim is Karina, Karrina, Alexis, middle name, Alexis, Smith, last name. And Batter's Intervention Program, Substance Abuse Evaluation and Treatment. The evaluation within 30 days of release, the treatment to commence within 60 days of release, maintain gainful employment, or file 2 applications per week, court costs and public defender fees of $150. Madam Clerk, I think that it's like $400 and something on a battery. Could you state what the court cost would be?
$622.
Oh, $622.
It's being reduced down to a misdemeanor, correct?
Misdemeanor simple battery, yes ma'am.
It'll be the $270 for cost, which is $201 domestic violence and $151.
So what the total amount of court costs, $622. Thank you. I think that is it, Your Honor.
So is that your understanding of what the agreement is, Mr. Barrett?
Yes.
And again, you've gone over this with your attorney, had all your legal questions answered,
Yeah.
and you believe it's in your best interest to enter into this plea agreement?
Yeah.
Okay. Based upon that testimony, the court will accept your plea and adjudication of guilt on the lesser included charge of simple battery, 11 months, 29 days probation, no violent contact with the victim, batter's intervention. That's a fairly long program, so you got to jump on that early, okay? Because you have to complete these before the end of your probation, right? So substance abuse, and that's separate, evaluation, the other issues and court costs that are contained within here. And they are payable during the term of the probation as well. Any other questions?
Your Honor, based on his representation that he has probation in Holmes County, there may be a hold or a transport to Holmes County, so probation may want to get up with him right away on the probation paperwork.
I would assume that, when they have a hold, is that generally what probation would do?
Yes, Your Honor.
Okay, so you did pick, you got that and made notes of that, he is on hold for several counties?
Or maybe
Okay.
Holmes County only, right?
Okay.
Yes, sir.
Holmes
Thank
County.
you.
Okay, very good.
Thanks, Mr. Gates.
Thanks.
And then we have the female she's ready, Mr. Gates is ready.
Yes, Your Honor, I think that may conclude our inmate 130 docket as well.
Your Honor, may I interrupt? Bowden hasn't been assigned to the public defender based on what Ms. Sharpless told me. He may be able to do a time served. I'm writing that up. I'll need a moment with him because it would get him out of jail. I think it would be very beneficial to the taxpayers
So
to...
why don't we do this? We'll finish this one, take a break, then we'll do that first up.
Yes, Your Honor. Thank you.
Counsel, you may
Yes, Your Honor.
announce.
Hannah Shaggers before the court, 22 CF 3144. It'll be a plea of no contest as charged.
What number is that?
I just have an issue.
What number is that on the document?
I wish I had it, Your Honor. We get 37.
37, thank you very
In
much.
addition to the save. May I approach, Your Honor?
You may. Thank you. Would you announce, Mr. Gates?
Yes, Your Honor. If I can have a second look at the score sheet with
Sure.
Ms. Jaggers. Score sheet 22. Priors. So 26.6. Dark score, the main score, Michigan may not. Okay. May I approach the score sheet, Your Honor?
You may.
I can give a copy to the probation officer so that she can follow along as well. Your Honor, Ms. Shaggers will be entering a plea no contest as charged. I have on there count 2 and 2. It should be count 2 and 3. It'll be a withhold adjudication. The felony counts, which are 1 and 2, should be adjudicated on the misdemeanor count, which should be count 3. And the felony counts of 1 and 2 should be sentenced to 3 years of probation concurrent. And count 3 of the information will be 90 days county jail with credit for all time served. Supervision will start upon her release from incarceration, waiver supervision fees, $967 of court costs, $150 public defender fee, required to do a substance abuse evaluation within 30 days of her release, any recommended treatment within 60 days of release, random urinalysis, 48 hours of community service work.
Very good. Ms. Jaggers, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of the plea agreement,
Yes, sir.
and I see that those same terms are contained in the written plea agreement that you've signed.
Yes, sir.
Have you gone over this in detail with your attorney? Make sure you had all your legal questions answered.
Yes.
And you're entering in this freely and voluntarily.
Yes, sir.
Understand that by entering into this, you're waiving the right to go to a trial and contest all of this. It's the final adjudication of your cases. Do you understand that?
Yes, sir.
And you believe it's in your best interest to enter into this?
Yes.
Very good. Based upon that testimony, the court will accept your plea. We withhold of adjudication on all counts, on the felony counts, adjudication of guilt in the misdemeanor count. In counts 1 and 2, 36 months probation. Count 3, 90 days in the county jail with credit for time served, and followed by the supervision of the other 2 counts. The court costs and fees. Of course, got to do the substance abuse evaluation within 30 days of getting out and follow up with treatment. Okay? UAs, etc. 48 hours of community service. Okay. Any other questions?
No, sir.
Thank you very much.
Thank you, Your Honor.
Okay. Let's take at least a short break, 10-minute break. I know we're running late, but some of us may be getting in trouble. We're running too late. So we'll try and go as quickly as possible.
and then Chartran.
Right, can we see Thomas Burton?
So, I know we're obviously running very late at this point. I don't know. I'm just wondering whether we're going to try and do all 4 of these today, or whether.
I just have 2 bond motions. I don't know what the other matters are, Your Honor.
Well, I understand that.
I can speak to that.
What's that?
I can speak to that.
I know that, just so the court's aware, I know that Mr. Meyer and I have spoken about Mr. Powell, and we intend for that matter to be continued, but I know Ms. Pierce is here, and I'm gonna let Mr. Morrow speak to whether we should do Ms. Pierce today, because I know he was speaking with Ms. Pierce whether she could remain in the courtroom or need to go.
Okay.
If she wanted.
Let's do this bond hearing, and then we'll deal with that.
Your Honor,
Go ahead.
I have a family fairly urgent situation that requires me to be somewhere at 5. So I was just hoping to.
I do too.
Motions.
I do too, and unfortunately, I'm not going to get there by 5. I apologize. You may proceed.
Your Honor, does the court have Thomas Burton Jr.'s motion to compel him for pretrial release? It was
I do.
22 CF 1674.
I do.
22 CF 1224.
Correct.
Your Honor, maybe I should highlight a few things that are in there. The most important parts are that the discovery that relates to this case of 22 CF 1647 relating to the FDLE has not been provided. This was a date of arrest of June 24, 2022, and it is not fair to the defendant to not have that FDLE this many months later. This chemical analysis is critical information without which the state can't proceed to trial. I don't want to say that we don't need that, because I need to be able to see that. If we were to do a notice of speedy trial, it might be produced at the last minute. In addition to which, there are 2 lay witnesses that we tried to depose that the sheriff's office could not find. These are the other people in the vehicle, including the driver of the vehicle and the owner, who was the front seat passenger. Both of these people could not be found by the sheriff's office, and they were released and not charged when they had drug paraphernalia admittedly in their possession. And had they been charged, they probably would be under probation right now and it'd be easier to find them. I'm asking Your Honor to please consider allowing him to be to have pretrial release in 22 CF 1647. Under the circumstances, it is my position that a signature bond should be imposed in both cases, with the possibility the court may wish to consider a pretrial release, such as pretrial services, GPS at the lowest permissible rate, bi-weekly urinalysis, and substance abuse evaluation within 30 days, with any recommended treatment to commence within 60 days. Thank you.
State?
Your Honor, the FDLE has, as far as I know, been produced. I have a new assistant. My former assistant helped my new assistant out and sent me an email that says the FDLE has been
Ms. Sharp,
produced.
I'd really like to see you when you're talking. So would you
sorry.
somebody slide some way?
As far as I'm aware, my assistant told me that the FDLE was produced in 22 CF 1647.
When was it produced?
I don't know exactly when she sent it over, but there's an amended discovery exhibit from February the 8th that says it was produced, and it has Pallavi Beer's name as the analyst on it. So I assume it was produced the same day, and I sent you an email that said it's been produced. The ride-along information, I know that there was an email to the sheriff's office, a public records request that was made. I am not in possession of that information, so the Okaloosa County Sheriff's Office would be the public records division at the sheriff's office would be the people to produce that for him. As to the lay witnesses, I gave him the address that I have, and I don't know what else to do about that. Mr. Burton had the 22 CF 1224 case with a possession charge in it when he picked up this case, 22 CF 1647, which has a trafficking charge in it, Your Honor. That leads me to believe that there are no conditions of bond since he got a new case, and the second case involves trafficking, which would adequately satisfy his appearance in court and him following the court's orders. So I ask the bond remains to be the same.
Mr. Medina?
Well, Your Honor, I haven't seen this amended discovery. I didn't see the email that Ms. Sharpless, I appreciate her representing that she sent me such an email. I don't know what it says.
Well, let me ask you this, Mr. Medina.
Yes.
You got the FDLE. Let's assume that the FDLE has not come back. I understand that's a problem. Is there some case law giving me ground that's grounds to release somebody on that?
The motion to compel is tied into the discovery rule. The discovery rule provides wide latitude and flexibility in terms of the measures that would be appropriate for enforcing discovery. So in addition to compelling
I'm just asking you if you've got any case law that would compel me. You're asking that you're laying the shoes of the state, which I understand. I guess at one level they're on the same team but they're an independent executive branch of the Florida government. Didn't hear anything that says that the state attorney's office has been derelict in what they've done. We all understand they're having some problems at FDLE getting the process out. We got problems across the state.
I don't know if the state attorney's office has been derelict or not. I don't know what the reason why this was delayed. I don't know where it has been, what the date of the report is. I don't know if the state can elaborate on what the date of the report is. I'm sorry, I don't have the information, having not seen it, having not been aware of it. But my position would be that this is in essence a renewed bond motion. So under the bond provisions, the court can consider a pretrial release, and under the statute that relates to bonds, is the court can take into account other relevant circumstances. So in essence, the court does have statutory authority under the bond statute, even if it didn't have authority under the other statute of the rule, which I think it does. I think the court could fashion that. I don't have case law on that subject. As to the other things, Your Honor, these are critical witnesses, and the state should produce, those witnesses should have produced.
Okay, so are they required to produce witnesses that they don't have access to? They've got the same problem too, don't they? Aren't you acknowledging that these are critical witnesses, Ms. Sharp? I mean, I don't quite understand. They've said, look, we've given you what we have. You can't locate them. We can't locate them. I'm not quite tracking what you're...
What it relates to, Your Honor, is his ability to get to trial. He's in jail on pretrial, without pretrial release. The point of somebody being in jail before trial is to be able to get to trial. He can't go to trial right now. That's not his fault. That neither the state nor we don't know where these people are. But it's not fair to him to be kept indefinitely in jail.
No, I don't think so. I think we go to trial, and the state has to prove beyond every reasonable doubt. If they don't have the witnesses, they lose.
Well,
I mean, I haven't heard the state arguing we want to delay the trial because we can't find these witnesses, we're asking the court to delay the trial.
Well,
I haven't heard that.
They very well may be providing exculpatory information.
Again, they said they've given you what you have. I don't know, what is the state supposed to do?
I think the state should stipulate to releasing him on bond until they can find the critical witnesses in the case. These are Section A of the discovery exhibit. If the state had them in their hands through the Okaloosa County Sheriff's Office, did not bother to get their addresses and their phone information and release them, the Sheriff's Department's hands are not completely clean in this situation. They should have found out the critical basic information for the witnesses in the case who were in the car. That is on the Sheriff's Department for doing a very sloppy investigation. That shouldn't be faulted.
I'm sorry, Your Honor, but the Sheriff's Office provided on the first page of the offense report an address, and that's what the Sheriff's Office needs to do in this case. If someone moves or changes their phone number, that is not on the Sheriff's Office. And I think that's inappropriate to say in the courtroom.
So the court, what I'm hearing from both parties, the court has discretion.
It's an ongoing discovery obligation, Your Honor.
To me, what trumps this thing is he's picked up another charge, and it's a serious charge, trafficking charge. So I'm denying the motion. As to the motion to compel, I don't even understand what you're asking the court to do.
Well, I was asking to compel FDLE.
Is the state not doing something they're supposed to be doing with regard to FDLE?
At the time I filed the motion, it was not. It's explained in it now. The FDLE is part of the state of Florida. The state of Florida is the plaintiff. The plaintiff should be able to provide the FDLE. If she's provided it, great. That would help potentially resolve that issue. I haven't seen it to examine it.
Your Honor.
No, I don't want to hear at this point. I haven't heard any of the state being derelict with regards to the FDLE. All I've heard is that there are some issues, but apparently what's been represented is that it's been provided to you. Am I hearing that, Ms. Sharpless?
Yes, Your Honor.
If you have not received something, Mr. Medina, after the representation by the state that they provided today, you can come back before the court, and I'll listen to you.
Your Honor, there's an entry, just so Mr. Medina knows, there's an entry on, I'm looking at STAC right now, there's an entry from February the 8th that it went to the PD1 email. So if you do not have it, when you get to the office,
Mr. Medina, your client wants to speak. You wish him to speak. I don't have a problem. If he wants to speak, I'll put him under oath, and he can say whatever he wants.
I think the court has issued a ruling. I don't have anything further to argue. I don't think it's appropriate for Mr. Burton to argue anything further on a motion. His counsel, if he wants to represent himself, he can ask for the PD to be ruled.
I don't want to. Okay. I don't want to. I just want to ask, am I still set for the trial tomorrow?
You said for coming to court tomorrow for a pre-trial, Your Honor. He'll be back. Next court date is tomorrow.
Okay.
Thank you.
Well, we need to be, tomorrow we need to know what the status is of all the witnesses, and we need to be looking at this to get this thing to trial so that Mr. Burton gets his day in court. And I'm going to do everything I can to make sure that happens.
I asked for a speedy trial, Your Honor, when I first asked for a speedy trial.
That's a legal issue. Take it up with your attorney. That's a formal file.
And Your Honor, I will let the court know while all this was going on, I did look at the discovery. It does say FDLE, but there's no report attached.
That might be in stack.
We're going to go tomorrow. We're going to meet on this. Let's get up to date with what's out there. What's the status of the motion? And like I say, if it's not provided and it's somewhere sitting out there, then you can reassert your claim for the motion to compel.
Thank you.
Okay. Counsel? Give us just a second here, Mr. Medina. I know you're trying to get out of here, and I'll try and move as quickly as I can. Where are we at?
Your Honor, I have Mr. Howe set for sentencing today.
Okay.
I spoke with the state on this. I'm going to ask to pass this to next week if it's possible. I know we're a little bit backed up on the 21st. If it has to be in March, I understand. The state's recommending a guideline DOC sentence, so it will be 6-1. To an extent, his incarceration will continue. The reason for the request is I have 2 witnesses here that I had never spoke to before. They want to be heard. I'd like an opportunity to go over their testimony with them, get their names, and get them properly listed. Second, I have a mitigation evaluation prepared by a psychologist. My intent was to let the state review and then come to court today and ask the clerk to file it under seal. I'm being told by the divisional attorneys that that's not something that happens in Okaloosa County. That's another creature of a scammy that I brought with me, so I want to get that properly filed ahead of
Get that
sentencing.
straight. We do things over here a certain way.
And by the time we get to March, Your Honor, I'll be squared away. I promise.
And Your Honor, I understand that you just got this case.
Like we have,
and I'm not
we get the
gonna
first
rush
page,
into this and-
we don't have the second.
We're not going to do it on the 21st.
No, I
And
will
I told him
say,
that would
we do
probably
have the
So,
Brady notice that they'd like to send us for FDA.
Yeah. So what do we have on the 14th?
We have that from Greg Anchors, but we don't have
At 2:30.
the Brady
Type of.
FDA mix up.
With
You did.
Gene Mitchell,
You did.
the type of motion, because that matters.
I just sent it to your email, so you can't say you don't have to.
So,
Steve Medina.
A 1 hour long hearing before Judge Ketchel is scheduled on March 14th at 2:30 on.
so we'll come back on March 14th.
Thank you, Your Honor.
To the,
That would be,
we'll say it at 2:30, but, you know, it might be a little later.
Understood,
in the
Your Honor.
afternoon.
He's not coming out.
Okay, so what's the situation with Pierce? Did you want to continue Pierce?
Your Honor, I'm ready to proceed on Pierce.
Well, let's deal with Mr. Medina's bond motion.
Certainly, Your Honor.
And how long do you anticipate, not trying to rush you, but how long do you anticipate on the Pierce?
Ms. Sharpless, how long is your argument going to be?
I would say maybe 20, 30 minutes, just to try to be a little
Okay, we'll get her done.
Mr.
Mr. Medina?
Take some testimony, but that's it, Your Honor.
Yeah,
Okay, that's good.
yeah, I don't think it's gonna take, I hope it's not gonna take longer than 30 minutes.
Just so the court's aware, I'm actually done for today. I'm writing plea agreements for tomorrow.
Counsel, you're welcome to stay in here. This is open to the public, and you're a step up from that, so you're welcome to stay.
As the court has said, we all have plans at 5 o'clock.
Yes, sir.
Your Honor, Steve
Counsel.
Medina with Israel Kane Chartran in 22 CF 2721. Your Honor.
And also 22 CF 3012, correct?
That's correct, yes.
Okay. Go ahead.
Your Honor, there is a no bond in 22 CF 2721, and I would ask the court to take notice that in 22 CF 21, we have filed in reciprocal discovery a
Hold on a second. Counsel, would you please move that outside or go to an attorney room? We've got a hearing going on here. Go ahead, Counsel.
Yes, Your Honor. In 22 CF 2721, which is the first of the 2 cases, it's a Grand Theft Auto, I think it's Grand Theft Auto, but the alleged victim was his significant other's mother, and she provided to us, and we filed in reciprocal discovery a notice that she does not wish to, a letter that she does not wish to prosecute. My understanding is, as part of a global deal, the state would even be willing to dismiss 22 CF21. So I would submit that to deny him pretrial release in 22 CF21 is really not a good use of the jail resources to keep him in jail on that one, given that
the victim doesn't want to prosecute, and that even the state represents that it would be willing to dismiss that case, at least under the circumstances of a global agreement. In the other case, $11,000 cash and professional, that is beyond his financial ability. We would ask the court to please consider a $11,000 signature bond. He represents that he's never failed to appear. I think you've lived in this area more than a year and a half, haven't you?
Yes, sir.
Okay. How long have you lived here?
October, the 1st of October. It's when we got up here to take care of our family.
Okay, well, when was that? A couple years ago? Okay. Well, Judge, he's been over here a while. His significant other's here. Although they've had some problems, in fact, she's the alleged victim in the 22 CF 3012. In that case as well, we filed from his significant other a letter from her asking that the charges with respect to her not go forward. There are law enforcement officer charges that the state would not be prepared to dismiss, counts 2 and 3 and 22 CF 3021, and he could, of course, be in court to answer for all the charges in that case. We would ask for a signature bond. Thank you.
Ms. Sharp.
So, Your Honor, he was out on bond in 22 CF 2721 when he picked up 22 CF 3012. Your Honor, again, I do have received Mr. Medina's communication from the victim. I do understand their input, and I have made a global offer that takes that input into account. However, Mr. Chartran still scores for prison. There are charges that the state will proceed on if Mr. Chartran chooses not to plead to those charges. So, given the fact that he was out on bond and committed a new law violation in contravention of the court order, I would request that the bond remain the same, given that the state does have charges it will proceed to trial on if he so chooses not to plead. So, Your Honor, I would request the bond remain the same.
Could I put that one thing, Your Honor?
You may.
With respect to the first case, I would respectfully request that you get a signature bond in 22 CF 2721 based on victim request. With respect to 22 CF 3012, if the court isn't willing to give him a signature bond on all charges, we would respectfully request the signature bond apply to counts 1 and 4, which are the counts that involve the alleged victim, his significant other, who has requested that those charges not be carried forward. So,
Are we up for pretrial tomorrow again?
Yes, Your Honor.
Yes, Your Honor.
I'm sorry, I didn't mean to interrupt.
That's okay, Judge. So I was just suggesting if there were any inclination of the court to continue cash professional on counts, it could be on the bonds with respect to counts 2 and 3 and 22 CF 3012 if the court wasn't willing to give him signature bonds on everything. Thank you.
Court notes the seriousness of the initial charges in 3012 and the fact that in spite of that there was an additional charge picked up. In those situations it is normal and appropriate to remove the bond to no bond, and that's what the court's going to do. I will, however, tomorrow listen to this case, figure out where it's going, and try and get this case ready for trial. Let's ramp it up. If the state can't come up with a witness or wherever they're at, if people don't want to pursue it and that affects the card, let's see where we're going with it and let's get this case resolved one way or another. So with that, but for today's, I'm going to deny the motion for reduction.
Thank you, Your Honor. May I be excused, Your Honor?
You may. And I hope whatever family obligations you
Oh,
have.
thank you. It's just,
have a good time.
it's not with a human being, it's with a family friend of the furry category, so.
I thought you were doing something on Valentine's Day or something romantic, Counselor.
I'm trying to get a dog out of the hospital.
You might want to revisit what your priorities are here tonight.
Well,
just say.
yeah. You don't know the dogs have high status in our house, so. Thank you, Your Honor.
Okay. Counsel, you may come forward.
Christy Pierce? Yes. Ryan Morrow from Ms. Pierce, Your Honor. This is 19 CF 2633 and 19 CF 2254. We're here today set for sentencing. I was not the attorney that entered the plea, but I have reviewed the agreement. It appears an admission was entered, previously adjudicated guilty, pleading straight up to the bench with an 1129 cap on incarceration, no cap on supervision.
You may proceed.
I didn't know if the state wanted to make argument or if you wanted to, if I could take some testimony from Ms. Pierce briefly.
You wish to make an opening statement?
Your Honor, I believe that it's appropriate in a sentencing hearing for the defense to go first. So.
Certainly, Your Honor. In this case, I'm going to be asking the court to reinstate probation for Ms. Pierce. She has prepared a statement. I would like to take some testimony from her whenever the court's ready.
Very good. Does the state wish to make an opening statement or reserve for?
Your Honor, just in opening the state would say that it's the state's contention that Ms. Pierce is no longer amenable to supervision and would request incarceration in this case. I'll reserve the rest for closing.
Very good. Counsel, you may proceed. And John, you can sit down if you want and call your whatever witnesses you wish to call.
I'll stay right here next to Ms. Pierce if that's all right, Your Honor. It's only going to be Ms. Pierce that will be here.
Who do you wish to call as a witness?
Just Ms. Pierce,
then
the
you
defendant.
Need to come up to the witness.
Okay. Can I?
And would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth, nothing but the truth, so help you God? Yes. Please be seated.
Good evening, Ms. Pierce. Would you state your name, please spell your last name for the record?
Christy Lynn Pierce, Pierce.
You're the defendant in this matter?
Yes, sir.
And you've entered an admission on this VOP?
What was that?
You've entered an admission on this violation of probation case?
Yes, sir. Yes, sir.
Okay. Can you tell the court a little bit about your circumstances while you were serving this probation sentence?
As far as like the VOPs that I got, or
your
like
life circumstances in general,
okay. Well,
leading up to the violation.
At the time of the first violation, the citation ticket that I got, I was driving while license suspended. The charge was deferred, and I successfully completed. I satisfied what needed to be satisfied with the ticket. It was a $250 ticket. I was up for reinstatement. It wasn't like I was just in my car driving around reckless. I did try to get other rides there. I was actually on my way to the DMV. Stupid, I know. I made the choice in the end because I didn't have Uber money, but I only had enough to pay the reinstatement fee. When I called, I couldn't do it over the phone because of the length of my suspension. So that's why I made the worst mistake to drive.
But the way that you resolved that particular citation, you ended up getting your license back, right?
Oh yeah, I've had my license back for a couple of years now. Don't quote me on that though, but it's been over a year I've had them back.
And the misdemeanor petty theft case that's mentioned in your affidavit, you took that case to trial, right?
I took that, yes.
And you were given a probation sentence after you were found guilty?
Yes, and that was the mistake that was made. Do you want me to?
Go ahead.
I was at the wrong probation office. I didn't know there was two different ones. Judge Mason had told me to check in after I did the 10 days. I did, but it wasn't specified which one. I checked in with my felony probation 4 times. It wasn't made aware to me until I went to court and Ms. Sharpless had said that I was not checking with probation and I did not pay the fees and the court fees, and I went to speak and I was told to be quiet, which, you know, from my attorney, which is understandable. After I left there, I went right to my probation, felony probation, and was like, why are you telling the state that I'm not checking in? I check in every time. I've never missed a felony probation check-in. I was arrested then on a misdemeanor VOP. Judge Mason, the next day at the bond, or the first appearance, she gave me a signature bond to rectify the situation. She believed that it was a mistake. I got out within 3 weeks. I rectified the whole thing. I paid everything off. I checked in with the right one. I was given all the right information, you know, so I could rectify the situation. Yesterday, I was in front of Judge Mason, and everything was dismissed. The FTA that falls under that second VOP was with the petty theft, and I have my medical records. I was actually in the hospital. I had a baby, and I almost died. I have my medical records, and it was preeclampsia, and I had to deal with it for 6 months after. It's no excuse, but my health, I really wasn't even thinking like, you know, the next court date or anything like that, because I was about to stroke out multiple times.
Suffice to say that was not a willful
yes.
failure to appear. You had
and also they had a Tallahassee address they were sending to. I don't know how the court got that. I've never been to Tallahassee. I've never lived there. In fact, I'm really not sure which highway to take to get there, but they understood that. Anyways, everything was dismissed yesterday in court.
And the misdemeanor VOP?
Yes, this was for the second VOP.
Because everything had been done?
Yeah, I rectified everything.
After you were given a bond, you immediately went and took care of all those things?
Yes, I did, yes. Okay.
And you spent a fair amount of this probation in the felony case homeless, correct?
Yeah, I've been homeless since, sorry.
Take your time.
I'm sorry. My anxiety is just really high. I've been homeless since November 8th, 2021. And I have receipts for the reasons why I haven't been able to pay so far, but my felony probation ends in June, so anyways, I've been staying in hotels and all that, but lately, things have looked up. I was able to get a car, so now I don't walk.
Let me ask some
yeah, I'm sorry.
Okay, that's okay. So additionally, you were unemployed for a fair amount of this.
Because of my pregnancy, I was so sick, yes.
But now you are employed, correct?
I have 2 jobs.
And where are you working now?
I work at Chipotle at the Commons, and I'm a rehire at Lulu's at the Mid-Bay Bridge at night.
When you say the rehire, what do you mean by rehire?
I used to work for them back in 2019 for a year or so, and then I left. But I left on good terms, just to venture into something else.
And correct me if I'm wrong, but for most, if not all, of this term of probation, you didn't have transportation either. Is that accurate?
No, right.
Okay,
Yeah.
but now you do.
And that leads me to, it was either $500 down on a vehicle or $500 towards my felony probation fees.
But another consideration of that was your homelessness, and you're sleeping in your car right now.
Thank you, and so I'm saving money. I will start to be able to save my paychecks to pay because I no longer have, these are all receipts from hotels. And
I want to ask about the allegation about contact with law enforcement.
Yeah.
Now, you weren't arrested in any of those cases, right?
No.
And it's your position that you asserted to me that you thought you only had to tell that if you got arrested or charged with something.
And charges were, that was my assumption.
That's not what those allegations are they?
I think that fell under these VOPs or something. I guess I failed to tell them I made contact with law enforcement on 12/7/2021 and March 2022. Ms. Sharpless is aware I have a couple of bad children. She dealt with them on a juvenile level. I believe those, I don't know for sure because I'm not for sure, but there was no arrest or charges. So
You didn't think you needed to tell
I
them?
didn't. I thought.
You admit that you did not tell them?
Yeah,
You
I didn't
accept-
tell them because I thought it wasn't, I thought it was only for arrest, yeah.
I understand.
Yeah.
Is there anything else you'd like the court to know before they impose sentences this afternoon?
On those two VOPs, I did pay a $2,000 cash bond to get out of jail, which after today will apply, I think, to my court fees. I did pay $2,000 cash bond. I did not use a bail bondsman.
And one more thing we didn't mention, you are expecting to have housing in March, correct?
Yes, I'm part of the, what do they call it? A rapid rehousing program. I got approved, but housing isn't available to the first part of March. So.
Anything else that you would have the court know to allow them to arrive at a fair sentence this afternoon?
It's just that I just feel like if you're able to allow me to leave your courtroom today and reinstate me, I'd be able to fulfill my money obligations. I've really been trying, Your Honor, and I have not reoffended since 2021 with those VOPs. I just go to work and that's it. I know I can successfully do what's right and finish it.
No further
And
questions?
I do have 3 children under the age of 12, so.
And they're going to be staying elsewhere until the housing comes through,
Yeah,
correct?
till March, yeah, they will be back the first week in March. Yes, sir.
All right, no other questions, Your Honor, thank you.
Sure.
Your Honor, I don't have any questions for Ms. Pierce.
Your children, where are they now?
They're in Illinois. They're in Illinois, but they can only stay until March. So it was giving me a chance to get back on my feet, get employment, and get housing back. Because they were homeless with me.
Where are they staying up in Illinois?
At my mom's. But she's an older lady, and she has the responsibility of my father, who had a massive stroke 6 years ago, she's the caregiver, so it's kind of difficult, especially with my child, who is going to be 1 in 2 days.
Thank you. You may step down. Counsel?
You hear from the defense first, Your Honor?
I'm sorry?
Argument?
Well, let's see what the state. So do you have any other witnesses?
No, Your Honor.
Okay. Ms. Sharpless?
Your Honor, the state doesn't have any witnesses, just argument.
Okay. You may make a closing argument.
Your Honor, I don't agree with the state that Ms. Pierce isn't a candidate for supervision. When I see the misdemeanor VOP, when she was given a bond and then she immediately went and did what she had to do, I couldn't ask for me myself for better evidence that she is amenable to supervision and that she will comply with court order. I do recognize what we have in the affidavit. It's troubling, but I don't agree that she's not a candidate for supervision. She doesn't score prison. She's here before the court on a cap of 1129, Your Honor. I'm asking the court to reinstate her supervision and let her finish it out. I do believe that she's amenable to the supervision. I do believe there was a lot of confusion on the front end. I do believe she was dealing with some rather incredibly difficult life circumstances that she seems to be nearly on the other side of, Your Honor. Once we get her housing in March, it's going to be a completely different playing field for Ms. Pierce. And I would be remiss to see her lose that opportunity on an incarceration sentence on this affidavit when I do believe she is a candidate for supervision, Your Honor.
Ms. Sharpless?
So, yes, Your Honor, the state's contention that Ms. Pierce is not amenable to supervision has to do with a few things. Firstly, the new law violations while on supervision. The order of probation clearly states, and the #1 rule of probation is not to get any new law charges while you're on probation. She did get that DWLSR, which I understand was diverted. However, that was a part of this violation, and she did admit that she did acquire that new charge. as well as this new petty theft. And, Your Honor, that petty theft actually occurred at the courthouse between her and the member of the bar. There was a scuffle. If the court will take judicial notice, or if the court knows about 21 MM 4456. And then also in that case, the court minutes reflect that failure to appear that she's talking about. The disposition of that was also guilty, so she was adjudicated guilty of that failure to appear for the misdemeanor offense. I do understand what she's saying about transportation issues, to be honest, Your Honor, and I'm not going to be able to contend because the court has the benefit of the violation report. It does not indicate that she wasn't reporting. It does not indicate that she wasn't keeping her daily activity log. Those are not on there, but what is concerning is that, again, in contravention of the court order, which is clearly stated, and when they check in at probation every month, they are given a piece of paper where they have to tell the officer what's been going on in the last month, and one of those things is, have you had contact with law enforcement? It's very clear, it says contact. The report says that she did not report the contact about the DWLSR. She did not report the contact about the petty theft, and it also states that there was a shooting at her home that, again, the state is aware of that. I believe that that was a drive-by shooting at her home. She did not report that contact, so none of that law enforcement contact was reported. And again, if she can't follow the rules of probation, the state is asking for 6 months incarceration in this case, Your Honor. I do not believe that she is a candidate for probation at this time, and would ask the court to incarcerate her and revoke and terminate her supervision.
The only thing I might add, Your Honor, and I don't have a way to verify this right now, or I don't have a probation officer to talk to, but my client's asserting to me that she did report the shooting contact. And she's been cooperative with the prosecution. She's out front of the courtroom with Mr. Rogers because she's the alleged victim in that case, one of them. But nothing further from me.
It wasn't like at me, like I wasn't involved in the thing. It was one of my sons, and it was crossfire. But I did report that. I absolutely did report that. And it all transpired. It went from my house on Newcastle. Well, it wasn't even my residence. I was staying there because I was homeless, to the hospital. And all the police there, they shut down the whole hospital and everything. So it was made very aware to my probation officer.
Okay, I'm going to take a very short break, and we'll come back in maybe 5 minutes.
Understood.
Okay. Bless you.
Thank you.
The court will begin by acknowledging that the defendant has clearly violated certain of the terms of the probation. Using more coarse vernacular, has screwed up a couple times. However, I think it's also important when we're looking at our criminal justice system to look at the positives that have happened. And against some odds, Ms. Pierce, you have largely turned the ship around in recent months. I'm impressed with your employment, the fact that you did stay in contact, and I mean, you made some mistakes. You drove when you shouldn't have. You made some mistakes, and it's going to be upon you to keep from continuing to make those mistakes, or you're not going to be able to be around your children. But based upon the whole totality of the circumstances which the court is required to do, the court is going to reinstate probation for a term of 1 year. And see if we can try and continue